5 people. That's crazy. I never start with 5 people. Um, since there's just 5 of us, well, 6 if you count me. Do you guys want to know how many days we have left? I added up all the minutes left in the videos, and I factored in the 1.25 speed that we play the videos at. And I know exactly how many more days we're going to be streaming. Do you want it to be a surprise? Or do you want to know exactly how many days we have left? I'm just waiting for chat. There's a delay. Unless I'm not even live streaming. No, I am. It's just a delay. Hoof. Okay, I'll take a poll. I'll take a poll. I'll leave it up for a while, and then like 30 minutes or an hour from now, we'll figure it out. All right. There's the poll. I'm going to press play.
Important things to do next week. Mr. McDonald has...
Oh, sugar. Wait a second. There's something I forgot to factor in, guys. Because there's no way to factor it in. There are times when they have sidebars and I'm actually here. And I fast forward those sidebars. That I don't know how to factor in. I don't know how. So it will not be. My date is wrong unless the only way my date is right is if there is no more sidebars in this whole trial. That would be hilarious though.
Well, by Friday. No, I'm saying we'll finish today. Yeah.
I am innocent. Wow, that's a lovely seal, isn't it? It's a lovely, lovely seal.
Gentlemen, please be seated. Mr. McDonald, would you resume the witness stand, please? And Ms. Clark, you may continue with your cross-examination.
Thank you, Your Honor. Now, when we left off, sir...
I will give you one spoiler, though, guys. As I was adding up all the hours, this face comes up again. Later, I think. Or he looks a lot like the other guy. The last guy, Rayner. So maybe it was Rayner. But he comes back. And then a pleasant surprise. Someone we saw in the prelim shows up.
We were discussing the fact that you were not aware of the history of the stock before you saw it on April 2nd, 1995. Do you recall that?
Checking in, so the history.
No, I do not know the history prior to that, how it was stored and maintained, no.
And you made no effort to determine what the history of the stock was with respect to how it had been handled before you saw it on April 2nd of 1995.
All right, we've established that already. Let's proceed.
I think I only asked about Fred Matheson. I wasn't like...
Let's proceed.
Well, can you tell us, sir, what effort you made to determine what the history of the handling and testing of that stock was before you saw it on April 2nd, 1995?
I did not make any determination of the history. My purpose there was to examine it as it was, in the condition received.
In that case, sir, then you cannot tell us whether the condition you observed on April 2nd was there before August 4th, 1994.
No, of course not.
Yes, Your Honor, I'd ask that this photograph be marked People's next in order, People's
553.
553.
I'm sorry. Did she just ask him if he knew if the blood was on the sock before the murders? Trying to figure this out in my head, because first off, if the blood was on his sock before the murders, then she can't really use that sock of evidence that he committed murder, right? So that doesn't make sense from a prosecutor's standpoint. And if the blood was on the sock before the murders, he had he was in a situation with them where they were both bleeding at a time before the murders. What is the prosecution trying to get at? She broke my brain on this one. This one doesn't make any sense.
Appears to be a photograph of a sock with a Q-tip.
You recognize what's being done in this photograph, sir?
Yes, I do.
That's a phenolphthalein test, isn't it?
Well, it's the sampling prior to the phenolphthalein test.
Yes, and the phenolphthalein test is a presumptive test for blood, is it not?
That's correct.
Now, if you would focus in, Jonathan, on that thing. Do you see that spot there, sir?
Well, I did.
Used to. You see it?
I see, yeah, there it comes. I see
There
a
you go.
spot, yes.
All right. Does that appear to be water, sir?
Objection, Your Honor.
Sustained. Sustained.
Does it look wet?
Objection, Your Honor.
Sustained. Sustained.
Appear wet?
Yes.
What does that look like to you?
Looks like a yellowy lips.
And does it look like it might be liquid?
Objection, Your Honor.
Sustained.
Is there a form of phenolphthalein test that uses distilled water, sir?
Yes, certainly. You have to have a solvent, either saline or distilled water.
And if that is the test being, does that?
Oh God, Michael, if she did that, you know what we would have to listen to? We would have to listen to days and days and days of testimony on how socks are made at a factory. And then we would need 17 sock puppet expert witnesses. So no, she cannot.
That appear to be the test being performed here, sir?
Objection, Your Honor. That's what appears.
Overruled.
As stated before, it appears to me to be the sampling phase. First you sample the material, and then you analyze it by adding the reagent to it. This would be just sampling, removing a suspect stain or a portion thereof for testing.
Okay, and you remove the suspect stain or a portion thereof by using a damp Q-tip to sample the area, is that correct?
That's correct. A damp Q-tip or whatever, filter paper you can be used also.
Okay. In this case, they used what appears to be a damp Q-tip. Would you agree, sir?
I would agree it's a Q-tip, and it apparently has been damped. It should be if it's going to be used.
Now, are you aware that of the date on which this photograph was taken?
No.
Now, sir, would it be important to you to know whether, as of the date, after the date of this photograph, assume for the hypothetical that it's August 4th, 1994,
Objection. No evidence as to when this
Overruled.
particular motion was made.
Overruled.
that the socks were frozen and unfrozen, twisted, cut,
Objection as to twisted.
Sustained. Rephrase the question.
Objection as to cut.
Overruled.
At this point,
Overruled.
would you agree, sir, that it would be important to know that after the point of the testing shown in this photograph, the socks had been frozen and unfrozen repeatedly? Would that be good for you to know?
Well, again, this is not testing in the photograph. The test followed the photograph. It would not be important for me to know because I saw what I saw at the time I examined it. If you want me to speculate as to what could have caused it, then if I knew certain factors, I might be in a position to speculate.
Then you would agree, sir, that your lack of knowledge as to whether or not the socks have been frozen and unfrozen repeatedly would have an impact on your ability to give us some opinion as to how the little balls that you saw got to be on the inner side of the sock that you saw on April 2nd, correct?
Objection.
objection to the formal question.
Overruled.
Freezing and thawing, I do not conceive as a mechanism that would allow the things that I observed in the cutout portion on the opposite side to have been formed. I can't imagine a mechanism by simply freezing and thawing unless you purposely put it in a high humidity cabinet that could cause that. I just don't see that that's a factor.
So it's your opinion then, sir, that even though you're not aware of how many times it was frozen and unfrozen, you're willing to give the opinion to this jury that that would have no impact on whether or not those little balls would appear on the other side of the sock. Is that correct?
Objection argument.
The statement I made did not say have no effect. I said that might explain an effect, but I cannot imagine how simply freezing and thawing, or the number of times it's done, would have any significant effect upon creating what I observed when I looked at them on April 2nd.
But you don't know, do you, sir?
Of course not.
And you cannot tell this jury whether or not that's how those little balls came to be on the other side of the stain. Isn't that right, sir?
Objection, you have to answer twice.
Overruled.
I don't know what you mean by that. You'll have to explain. Is that supposed to mean a mechanism? Could you rephrase that, please?
You cannot tell us, sir, whether or not, you cannot state to this jury that the freezing and unfreezing process absolutely did not cause the appearance of those little balls on the inside of the sock that you saw on April 2nd, 1995. Isn't that true?
Objection, you have to answer twice.
Overruled.
No scientist can state absolutes. Of course not.
And you did not inquire, you examined these socks with Dr. Lee on April 2nd, isn't that right?
That is correct.
Did you discuss with him his examination of the socks on February 16th, 1995?
No.
Were you aware of his examination of the socks that he had conducted on February 16th, 1995?
To the extent that he just observed them, I do not believe he made a microscopic examination at that time. That is my best recollection.
But you do not know.
I don't recall further, so I don't know.
And you do not know whether he, in the process of his examination on February 16th, 1995, twisted and pulled the socks in an effort to get a better look at any side of it or any aspect of it, do you?
It's because of the shrinkage. They had to twist and pull. That's why.
Are you aware, sir, of the fact that LAPD set up a microscope for Dr. Lee to use in his February 16th examination?
No, I was not aware of that.
And in the course of a microscopic examination, sir, in your experience, can it occur that material or fabric will be pulled or twisted in an effort to get a certain area under the field of view?
Certainly.
And would it be important to know whether that had occurred on multiple occasions with this particular sock?
It could be, but I can't imagine exactly how.
But it could add important information, sir, with respect to determining how those little microbes got onto the side of the sock where you observed them in 1995.
Sustained. Sustained. Raise question.
I'm sorry. Little balls.
Not microbes. Microbes are alive. Now I forgot the question.
Could it be important information whether or not the sock was repeatedly manipulated and twisted during repeated microscopic examinations to determine how those little balls got onto the side of the sock when you observed them on April 2nd, 1995?
Yo, I'm never
I
going
can
out to eat
imagine
with
how.
Maiko because he would. It doesn't take much to have me say something completely inappropriate at the wrong time.
I really don't see how manipulating the fabric could create dried balls of red fluid inside of a sock. It may be possible, but I have no idea what the mechanism would be that could cause those to form simply by manipulation. They were dried and they were wet and they dried.
Let me ask you something, sir. You said you observed one of those
I
little
gotta
balls
go.
to be adherent
I'll be right
to
back,
the fiber.
guys.
Is that correct?
Objection, that's not his testimony.
Overruled.
I observed several, I think half a dozen at least. We photographed the one that showed the bonding to the fiber the most distinctly.
Okay. Is it, sir, based on your examination, one was bonded well enough to photograph? Is that correct?
Objection, that's not his testimony.
Overruled.
I think they were all bonded, but this one showed the bonding to a fiber that was also part of the woven thread. That's the reason it was selected.
And that's the reason you took only one photograph, although you saw 6 or 7 of those little balls. Is that right?
Now, I didn't take the photographs. Dr. Lee actually clicked them off. I observed them.
You observed them, but there was only one photograph taken. Is that right, sir?
It's the only one that I have seen. I think it's the best representation, and I'm sure that's why he enlarged it.
Is your answer yes?
What was the question? Did I observe just one?
No, no. Mr. McDonald, please listen to the question. I asked you whether there was only one photograph taken of those little balls that you saw on the inner surface of the sock.
I answered that when I said Dr. Lee took it. I did not take any,
The question is only one photograph, correct?
to the best of my knowledge.
And that one photograph was taken because, in your opinion, or in your collective opinion, that demonstrated most clearly the bonding of that little ball. Is that correct?
That is correct.
Now, let me ask you something. With respect to that little ball that you saw bonded, what test did you perform to determine whether it was in fact adherent to the fabric or simply lying in the weave where you saw it?
It seems to surround the fiber or the thread-like material to which it is bonded. and it didn't move, so it didn't fall off. We're dealing with something extremely small. We didn't do any testing. To try to abrade it would perhaps fracture it, but exceedingly small. We did no actual testing except observation.
All right. As a matter of fact, those little balls that you saw, you said 6 or 7 of them?
Yes.
Did you make any effort to quantify those little balls?
As to volume?
Yes, as to volume, sir.
No.
If you took those 6 or 7 little balls and put them all in a purple top tube and stacked them on top of each other, could you see them?
Not without a microscope, or unless you're extremely myopic.
And yet the stain on the outside of the opposite side of the sock, you said was 50 microliters, 60 maybe?
Yes.
And all you had were those 6 little balls, 6 or 7 little balls that you couldn't even see if stacked up together with the naked eye. Is that right?
Or grouped, yes.
Now, with respect to the manipulation of the sock, sir, you indicated that you strike that. These socks, they were stretchy, elastic in nature, were they not?
Yes.
Blood, when it dries, is not elastic, is it, sir?
No.
Now, if you were to have blood dried on a sock, and then you were to stretch it, blood might flake off, if even in only microscopic amounts. Would that be true, sir?
Yes, it is.
And if the sock is stretched in some fashion, which causes the blood to flake, and then the sock is compressed through storage in a bag, there will be some microscopic or some flaking happening of the blood that has dried on the sock. Isn't that correct?
That's correct. There should be.
And if, in fact, the blood that has hit the outer surface of the sock has seeped through to the inside, if it rubs against the other side in a dried condition, causing by friction, there will be some flaking as well, will there not, even if only microscopic in amount?
Well, it's even simpler than that. It wouldn't have to flake off and go through the sock, because when it dries, it's through the sock to begin with. So it could flake off from the inside of the outside surface at that point. And then if it landed on the inside, you would have some flakes on the side opposite the inside. Yes, that could happen.
And you indicated that you were not present when Dr. Lee did his examination of the socks on February 16th, 1995. Is that right, sir?
That is correct.
Now, on the date that you did the examination with him, did you turn the socks inside out?
I think we did after the initial photographs were taken.
And when you say the initial photographs were taken, are you talking about the photographs of the little balls?
Yes, I believe we took all the photographs before we did any what you could call stretching or manipulation of the socks. We left them quite flat as we took them out.
Do you know whether anyone turned those socks inside out or twisted them in any fashion before you made that examination on April 2nd, 1995?
No, I don't.
Would that be information that you would like to have, sir, informing your opinion as to how those little balls got onto that side of the sock?
No.
You don't think that would be important to know?
No, not unless you added many factors, such as if the socks were wet and you turned them inside out. That might make a difference, but you're exposing the inside, where I detected these small balls of red material, to the outside at that point, so you're defeating the purpose of transfer. That would no longer be in contact with the area that was stained, so you're losing ground that way if you're trying to transfer them.
No, let me ask you this, sir. You don't know whether they were wet on some occasion after the blood was detected on August 4th with that Q-tip, correct?
No,
No foundation for that.
Sustained. Raise the question.
Well, Your Honor, I have a series of 3 photographs I'd like to show to the witness. I'll show them to counsel. Be marked Peoples 554,
554.
555, and 556.
Yes, 554 is the first number.
All right, so I'm going to show you a photograph. You recognize him? Do you recognize the person in that photograph, sir?
yes, I do.
Who's that?
That's Dr. Henry Chung Lee.
All right. Did you see him perform the manipulation with the sock that he is in this photograph in your presence on April 2nd?
No, I did not.
Did anyone, were you ever...
I'm sorry, can we have a sidebar?
Let me see the photographs with close work, please.
These photographs, we will stipulate, were taken on February 16th, 1995.
All right, is that agreeable to the defense?
Yes, on the date when Professor McDonald wasn't there.
That's correct. Thank you.
Okay.
So you did not see this manipulation by Dr. Lee, correct?
I wasn't there. No, I did not see them.
And he didn't do that kind of manipulation again in your presence on April 2nd, is that right?
If he did, I didn't see him do it. I don't believe he did.
I'm showing you now People's 555. Again, you recognize Dr. Henry Lee?
Yes, I do.
This is his manipulation of the sock on February 16th, 1995 again.
Now, that appears more of a manipulation than the first one. The first one, I'd say, just holding it up, not manipulating it. This one, it appears he is either turning it inside out or at least manipulating it in some fashion.
And is that something that you also did on April 2nd, 1995?
We turn them inside out, yes.
In the manner in which Dr. Lee is doing?
In any manner you can to turn socks inside out. I don't think there's much choice. This looks about the only way to do it.
All right, now I'm showing you People's 556. Appear to be a photograph of Dr. Lee taking a picture through a microscope, sir.
Yes, he's taking a picture through a stereobinocular microscope using the right ocular.
And again, we stipulate this is February 16th, 1995. Is that right?
I don't know.
No, I'm asking counsel.
I'm sorry.
Oh, yes.
So it would appear that he did examine the socks under a microscope on that date, correct, sir?
Yes, a low-power stereobinocular. I think the maximum magnification is about 25 diameters with most stereobinocular microscopes.
Okay. Now, the microscope that you used on April the 2nd, 1995, had what power magnification?
It was 7 to 70.
You do not know, or do you know for a fact, have you ever seen this microscope up closer?
Not this particular one. No, I have one, but not exactly the same model.
So are you sure when you say that this the greatest magnification power on this microscope would be 25 times?
No, that's why I said they're usually 7 to 25.
Now, the photograph that you've shown us here, of the little ball on the inside of the sock, that was taken on April 2nd when you were present, correct?
That's correct.
You don't know of any such photographs that were taken on February 16th by Dr. Lee, do you?
No, I,
No foundation for that question, even though he was
Sustained.
there.
Sustained.
Have you been shown any photographs taken by Dr. Lee on February 16th showing the little balls on the inside of the sock?
no, I have not.
And the photograph that you produced here in court showing the little ball on the inside of the sock, the one that you have shown, is what magnification?
I would approximate the magnification of the actual print to well over 100 diameters, but I have not made that calculation. I do not know the diameter of the first picture that I saw, which is a 4 by 6. And if I don't know how big the magnification is on this, I could ordinarily make the correction, but without knowing a starting point, I can't proportion it up. I'm estimating from memory of what I saw that would be about 100 or more diameters. Dr. Lee could tell you exactly.
All right, Ms. Clark, our record is rather sloppy here. You're referring to photographs of red balls. Which exhibit are we talking about here?
And I can't remember their defense.
I think it's 1278. I think. I'm not certain.
1278?
Yes.
Because one is with
You're
just
referring it to a counsel, so you tell us which one you're talking about.
I'm going to...
That's 1278.
That one.
That large one, 1278, Mr. Gordon?
Yes, Jim.
1278.
Is that 1278? Okay, this, the one we're referring to, sir, is the one with the little ball in the blue circle?
Yes,
That's 1278.
correct.
Okay. You were not shown any such photographs that were taken by Dr. Lee on February 16th, 1995, correct?
That's correct.
To your knowledge, do any exist?
Objection.
Sustained. He hasn't seen any.
All right, sir. Now, were you aware that on August 4th, the same day the socks were tested, given the presumptive test for blood, the first step of which you saw, the sampling of which you saw in the photograph, Susan Brockbank also examined those socks for hair and trace. Were you made aware of that?
I believe I read that, yes.
And that has no impact on your opinion as to how those little balls got there?
No, it does not.
And you were also made aware then that Greg Matheson performed serological testing for PGM subtyping on that sock after August the 4th. Were you made aware of that, sir?
Objection. It's misleading for your approach.
Overruled. Rephrase the question, though.
Greg Matheson performed PGM subtyping on that stained area of the sock after August 4th. Were you made aware of that?
Objection, because he cuts out a portion and removes it.
Yes. Rephrase the question.
Were you made aware of the fact, sir, that that to perform PGM subtyping testing, Greg Matheson cut a portion out of the sock in order to perform that testing,
Yes,
and that he had to handle the sock in the process of doing that,
obviously.
and that has no impact on your opinion as to how those little balls got there?
No, it doesn't.
Now, you prepared a report in this case, did you not?
Yes, I did.
And that report is dated July 11th, 1995?
I believe it is.
You've been working for the defense since August of 94, is that right?
Well, that's when they first contacted me. I actually didn't have anything to do until I had made a trip to Albany, I think in December.
And this report is the only one that you have prepared in this case, correct?
That's correct.
And it details only your observation of the one area of the sock where you saw those little balls, correct?
That's correct.
You examined both socks, didn't you?
Yes, I did.
And there's nothing in your report about the other sock, is that right?
No, there isn't.
Or any of the other stains on the sock that you did observe?
That's correct.
So it's just your report is confined to the one stain that you've testified to here in court, is that right?
That's correct.
Now, if I understand your testimony correctly, sir, the inside of that stain, I'm going to try and number these surfaces, make it easier. The outside portion of the stain where the blood was first received is surface 1. Inside, surface 2. The inside of the opposite side, surface 3. Okay? It's your testimony, sir, that the transfer to surface 3 came from surface 2. Is that right?
Yes, if it's transferred from that surface. Again, I did not determine what that material is. The only way it could have gotten there is for a liquid that is red to have gone from surface 2 to surface 3.
And now you've testified that you did not perform any test on the cutout area, on that cutout fabric from the center of the stain to quantify how much blood was in it.
That's correct.
Now, if as a matter of common sense, would it be fair to state, sir, that the more blood you have on the inner aspect of that stain, the more little balls you expect to find on the opposite side?
It's vague as to inner aspect.
Sustain. You just finished numbering the sides. Won't you?
All right. The more the more liquid or blood that you have on the area of surface 2, the inside of the sock, the more little balls you're going to expect to see on surface 3. Is that right?
As you said, it would be more likely. It's common sense, certainly.
And of course, this assumes that the little balls on surface 3 can be attributed to the stain on surface 2, correct?
Absolutely.
And you have not said that you make that assumption, have you not, sir?
You cannot say that you haven't
No,
said it, have you not?
See?
All right.
Clear to me. You indicated that, I believe in your direct testimony, you made the statement that if the stain in surface 2 is related to the little balls on surface 3, that they would have gotten there when wet. Do you recall that?
Yes.
But you cannot say that the little balls on surface 3 are related to the stain on surface 2, can you, sir?
No, I can't.
Now, it would be true, would it not, that the more blood you have on surface 2, the more little balls you expect to find on surface 3,
Only if the little balls are blood.
if they are.
Yes, certainly.
And you found only 6 or 7, is that right?
That's the number of what I would call balls, which looked like a wet material that dried, adhering to fibers, yes. I saw other red spots.
Let's just talk about those little balls for a second. You only brought in a photograph of one of them, correct?
I think we've asked this question now 3 times, Counsel.
Why weren't all of them photographed, sir?
I have no idea. We photographed the most representative. Dr. Lee, again, took the pictures, and that's a question you'd have to direct to him. I observed them.
Now, you made no attempt to quantify the volume of those 6 or 7 little balls, did you?
We've asked that question.
Okay. You indicated that there were also other little flakes.
There are many red spots that show up in the photograph that has been introduced that are clearly little red areas. And if the microscope was adjusted in its depth of field, in other words, focused, you would lose the one that we have photographed, and then you would see others. So they're clearly evident. There are red areas in there, and those are the areas to which I made reference.
But they are not photographed, are they, sir?
Yes, but they're out of focus.
So you can't see them in the photograph that you took.
You can see them, but you can't resolve them.
So did you make any attempt to have a photograph taken that would resolve them so the jury could see them?
Sustain. Rephrase the question.
Did you make any effort to take a photograph that would have those flakes that you saw in good resolution?
Objection, he's not talking about flakes, he's not talking about flakes.
Full rule.
The photograph that's introduced shows the best representation of the drying of a red fluid. Other red spots could be flakes, as you just stated. They could have been other of the red balls we saw. I cannot tell because they're so far out of focus. They are not resolved.
Though these little balls are a very important aspect of your testimony, are they not, sir?
Objection, argumentative.
Sustained.
All right, sir, in your terminology, a swipe is different than a compression, is that right?
To the extent that one involves lateral motion, the other involves compression, they are both transfer mechanisms.
They are both methods of transfer, is that what you said?
I said they're both transfer mechanisms.
Nevertheless, are they separate and distinct mechanisms of transfer?
Yes, as opposed to other means of staining, such as dripping and projection.
Well, you took great pains to explain to this jury, did you not, that this was a compression and not a swipe.
Objection
Is that right?
very painstaking.
Sustained. Phrase the question.
You went into some length in your testimony, sir, to describe for this jury how this was a compression and not a swipe.
Objection,
Sustained.
argumentative.
Excuse me. Sustained. Phrase the question.
Sir, were you attempting to explain to this jury the difference between a swipe and a compression with regard to your observation of the stain on this sock?
I thought I did it. I didn't attempt. I thought I explained it clearly enough, the difference. Yes.
And why did you want to explain to them the difference between a swipe and a compression?
So they would know they're both surface. I think I was asked if it was a swipe initially, or that came up, so I differentiated between the two. I said I looked to see if there were any trailings or featherings to see if it was a swipe. The difference between the two is really not significant. It's just a matter of my classification.
If it's not significant, sir, then why did you draw a distinction before the jury?
Because there is a distinction.
Then some transfers are swipe and others are a compression. Is that right, sir?
That is correct.
And they are distinct in your opinion.
They're different. One involves lateral motion, the other does not. That's the extent of the difference.
Okay. So a swipe could occur if I move my ankle across a wet surface. Is that right?
Objection is vague as to wet surface.
Sustained.
A swipe could occur if I move my ankle against a wet wound.
Certainly.
Now, your report, sir, is an accurate summary of your findings with respect to the sock A, is it not?
I believe so, yes.
And you took pains to make sure that it accurately reflected your findings in this case, did you not?
Objection as to pains.
Full rule.
I prepared it as accurately as I could at the time. I have no reason to suspect there's any error.
And you signed the report, did you not?
Yes,
And you reviewed the report before signing it, I take it?
I usually do.
And you examined that report before you testified, did you not?
Not recently. I did it, I think, 2 trips ago.
You prepared that report, sir, based on your observations of April the 2nd, 1995, is that right?
That's correct.
And in that report, you documented what your observations were.
To some extent, yes.
But it was an accurate summary, was it not?
I believe it to be.
Do you have a copy of your report here, sir?
Yes, I do.
Would you mind getting it out, please? Thank you. Sir, let me direct your attention to paragraph 4. Did you not write in this report, sir, when this sock is laid flat, the stain described in point 2 is directly below the stained area described in point 1. The only reasonable conclusion, therefore, is that the fluid that caused these stains was swiped against the outside of the left side of the sock. That is what you wrote in your report, is it not?
That's correct.
And you consider that to be an accurate depiction of what you observed on April the 2nd, 1995. Is that correct?
That's what I wrote, yes.
That's what you wrote. And yet you testified to the fact that you now believe that to be a compression and not a swipe. Wasn't that your testimony, sir?
That was my testimony.
Now, sir, wouldn't you agree that with respect to the differentiation that you have made, the distinctions that you have indicated you made between swipe and compression, that was an important distinction, was it not?
It's not important at all, as I said. Swiping shows there is a lateral component to a compression. They're both transfer mechanisms. Compression occurs in swiping. And I wrote swiping here. It would not matter whether it said compression or swiping. This pushing of blood or any fluid into a fabric is a compression.
And yet,
Swiping merely means there's lateral movement accompanying it. When I looked at it here, it appeared to be swiping. I have since seen enlarged photographs that we took that show that the swiping appearance, which is on the surface of the fibers, seems to be fairly uniform on both sides. So now I would say it's more likely a compression only. Both are compression. One has lateral movement. I describe lateral movement as well.
all right, did you take any notes at the time that you made your observations of this sock to document what you saw?
Yes, very, very few. Dr. Lee was described.
Did you take, you personally took notes, sir?
Yes, very.
Did you turn them over to the defense?
Yes.
And they can turn it over to the prosecution, Your Honor.
No, they have not.
All right, we'll take this up later. Proceed.
May I see those notes, sir? Thank you.
Welcome.
Tell me where in those notes, sir, you indicate that there was no lateral movement in the stain that you characterized in your report as a swipe.
I don't characterize it either way.
And tell me where in your report you demonstrate or you document your observation that there was no lateral movement.
I don't believe I did.
And tell us where in your report you document the observation of voids that you've testified to here in court.
I don't believe I did that either.
Now, the lack of lateral movement and the appearance of voids were the indicia that you testified to as evidence that this was a compression and not a swipe. Isn't that your testimony?
That's correct. And when I indicate voids for descriptive purposes, that's one thing, but I don't have to indicate them to know what I'm seeing. So I know what the meaning of the term is. And that's why I wouldn't bother to put there are voids here, there are voids there. That is part of seeing a compression transfer or a lateral transfer.
But you did not put down compression transfer in your report, did you, sir?
No, it was written for attorneys, not scientists.
Sir, you are aware of the fact that counsel has retained you as an expert, isn't that right?
I hope so.
And you are aware of the fact that the report that you give to them is turned over to the people as well before you testify.
Certainly it is.
You filed no addendum to your report to reflect the change from swipe to compression, did you?
There's no change. They're both transfers.
They are both transfers, but you made a distinction. You made a point of telling us it was compression and not a swipe. Isn't that right?
That is the way it appeared at the examination. The photographs I examined later showed it to be more uniform, and therefore I concluded it was more likely simply a compression. It could still be a swipe.
And you filed no addendum to indicate to the people that you were going to change from the swipe that you indicated in your report to a compression that you testified to here in court. Isn't that right?
Objection on the matter.
Sustained. Rephrase the question.
What effort did you make, sir, to inform the people of the fact that you weren't sure if it was a swipe or a compression, but you were leaning towards compression?
Objection of relevance to what was known by the people.
Sustained.
Sir, knowing that your report said a swipe and said nothing about a compression, wouldn't you agree it was very misleading not to make an effort to inform?
Sustained. Argumentative counsel.
You did not write any new report to indicate that you were uncertain as to whether it was a swipe or that you had changed your mind, to say now that it was a compression.
From July 11th, I haven't had time to read my initial report. I've been traveling. I have not made any addendum, no. There's no correction to be made.
No correction to be made because it could still be a swipe. Is that your testimony?
It's a matter of interpretation. If you agree that the fine blood on the surface of the fibers is uniform on each side of that elliptical stain, then it's more likely compression. It's a compression mechanism if it's a swipe. It could be that the leading edge and the trailing edge are basically the same geometry. It's a distinction that is really, in my mind, totally irrelevant.
So to you it makes no difference whether you call it a swipe or a compression. Is that your testimony, sir?
A swipe is a compression with lateral motion.
Do you recall how many times in your testimony on direct examination you said that this was a compression and not a swipe?
I may have said it several times. I have no idea how many.
And if that is the case, sir, that you said it several times, what would be the point of that if it were unimportant to distinguish between the two?
Sustained.
If it makes no difference, sir, then why testify before this jury repeatedly that it was a compression and not a swipe, if it doesn't matter?
Well,
So they would be reminded and understand it.
But you didn't make any effort to tell this jury that it didn't matter whether you call it a swipe or a compression until just now. Isn't that right, sir?
Sustained.
You did not tell the jury before cross-examination that it didn't matter whether it was a swipe or a compression, did you, sir?
No, I did not.
Objections.
Oh,
Now, Now, the notes that you have before you that were made contemporaneously with the observations on April the 2nd contain no description of little balls, do they?
No, again, I was not the scribe. I made a couple of very simple sketches, and Dr. Lee made all the tests and made all the detailed notes.
And can you tell us, sir, if you have his notes with you?
I believe I do have his notes.
Please look at his notes and tell us whether Dr. Lee has any description in his notes of little balls, lateral swipe, or voids.
No, he only mentioned that he took photographs of them.
He mentions that there are photographs taken of the holes. Isn't that right, sir?
Photographs taken, and he indicates little tiny dots within the cutout area. He states blood-like materials were observed on the inner surface of the other side of this cut, and he's got many little tiny dots, and it says photographs taken, photomicrographs.
And where is the description in his notes of lateral swipe, excuse me?
He doesn't use those words. He says a reddish-brown color he shows it around the cutout area.
Mm-hmm. There is no note there concerning lateral swipe, isn't that right?
Not on this page, no.
Nor on any page of
No,
his notes.
none
is
that
there?
I recall.
Right. And there's no mention in there of voids either, is there?
There was mention of voids and lateral transfer, but not in his report. We discussed it.
There was verbal discussion on April the 2nd. Is that what you're saying, sir?
There was,
But there is no written record to document that. Isn't that right?
not that I'm aware of.
And the only written record that you made concerning your observations of the socks with respect to the nature of the stain and the little balls is the report dated July 11th. Isn't that right?
That's correct.
So between April the 2nd and July 11th, you made the observations on April the 2nd, but you wrote nothing down concerning your observation of the little balls, the voids, the lateral swipe, until July 11th. Is that right?
That's correct. I wasn't in the country.
So you wrote that report from memory. Is that right?
Yes. And the very, very few lines that I wrote in my description, which are in your possession.
I'm sorry?
The few notes that I made are in your possession. I referred to them.
No, I gave them back to you. Didn't I?
Oh, you did? Oh, I'm sorry. Yes, you did. Thank you.
But these notes do not contain, excuse me, sir, a description of evidence, do they?
No, just a sketch.
As a matter of fact, those notes just document your receipt of the evidence and the date and time and what you got. Isn't that right?
Well, it lists the time that was spent examining the two items, 42A and B, according to my notes, and the length of time.
Now, your examination on April the 2nd was done with a very high-intensity light. Is that right?
Yes, high intensity.
And a microscope. Is that right?
Correct.
And you will agree, will you not, that the observation of blood on those socks was a difficult one in view of the dark color of the fabric, sir?
Not when you've got good high-intensity illumination. It would be difficult in this room, yes, but under the conditions that you would use for an examination, it was not difficult, it was straightforward.
And again, though, when you're talking about high-intensity light, can you explain to the jury what you mean by that?
High intensity is more lumens per square centimeter. A pocket light like this can give extremely high intensity right at the end, much more than a 1,000-watt bulb would give here on the ceiling, if the bulb is on the ceiling. So high intensity is the concentration of light in a given area, and it's expressed physically as lumens per square centimeter.
So it would be, if we were to light up this courtroom with that kind of high-intensity light, would we all be wearing sunglasses?
We ought to be. I would be if I could, or I'd close my eyes.
Now, with respect to the distinction between swipe and compression, sir, you did indicate that you observed crime scene photographs, correct?
Yes, I did.
Can I approach?
Thank you, better. All right, Ms. Clark, you may conclude.
Sir, now in characterizing the stain on the outside as a swipe and then changing your testimony in court here to a compression, where you would,
Sustain. Rephrase the question.
you initially characterized the stain as a swipe, is that correct in your report?
In the report, yes.
And then you came in and you testified to say that it was a compression and not a swipe, is that correct?
No, it could be a swipe if the leading and trailing edges are uniform, as they appear to be in the large photographs that I found that Dr. Lee had taken.
So you're saying it could be either one at this point?
Yes, they're the same thing. They're both compression transfers. One has a little more lateral motion than the other.
One has a little more pressure than the other, doesn't it, sir?
Not necessarily, no. You have to have pressure or you won't get any transfer at all.
All right, so compression then could be from touching,
Yes, that's compression.
could be from pressing,
Touching is pressing.
okay? So you don't, what you're saying, sir, is that there's no particular amount of pressure implied. Any pressure will indicate compression, is that right?
There has to be sufficient pressure to transfer a liquid to the surface, and that's very minimal when you have a liquid.
In characterizing it as a compression instead of a swipe in your direct examination testimony, were you attempting to be more helpful to the defendant?
Absolutely.
Sustain. Argument.
Well, in attempting to in characterizing the stain as a compression as opposed to a swipe, were you attempting to make it sound more sinister, Mr. McDonald?
Objection, Your Honor.
Overruled.
I am a scientist, not an advocate, and I am not changing, modifying, or correcting anything for anyone's benefit except to clarify the matter to the jury. That's my purpose here.
Nevertheless, would you answer the question, sir? Do you think, in your mind, that saying it is a compression makes it sound more sinister than a swipe?
Sustain. Sustain.
You saw photographs of the crime scene, have you not?
Yes, I have.
And let me ask you this, sir. If someone wearing the socks that you saw were to step near to the body of the victim, Nicole Brown Simpson, near enough for the ankle bone to come in contact with her bloody hand, could that cause a compression transfer?
Certainly.
Could it also cause a swipe?
Yes.
If she were to reach a bloody hand out and touch her thumb or finger or hand to the ankle of Mr. Simpson wearing those socks, could that cause a compression or a swipe?
Rephrase the question.
Oh. If Nicole Brown Simpson reached out a bloody hand to touch the ankle of the murderer wearing those socks, could that cause a compression or a swipe transfer?
Objection, no foundation.
Overruled.
Certainly it could. Anything that has blood on it can either be projected and touch the area that's stained, or this area that's stained could have come in contact with it. It's simple transfer.
Well, for example, I see the way you're sitting, sir. I can't demonstrate this, obviously. But if you were to, can the jury see the way? If you were to move your knee back, sir,
My knee?
yeah, to where your ankle bone, the bony protrusion of your ankle, was on top of your knee, could that produce a compression or a swipe?
If one surface was wet, yes.
Now, you noted, sir, that the stain appeared to be in the area of the ankle where there would be the bony protrusion of the ankle, correct?
It appeared to be in that general area. I don't know if the socks were put on, if it would be at the outermost portion of the apex of that circular area, but in that general area, yes. It very well could be at the extreme of the ankle bone.
Okay. And by the extreme, you mean the highest point, the point that protrudes the most?
Correct. On
Now-
either side of the leg. There's one on each side.
Right. And by the way, sir, by looking at the sock, could you tell whether it was a right or left sock, sock A that we're talking about here?
No.
Okay. By the way, and did you happen to ever look at a photograph of the socks in the condition in which they were found on the bedroom floor?
I've seen some pictures of it, yes.
This has been marked so many times, I hate to mark it again, but it's People's 127 already marked. I have one handy, if I may.
127.
Let me ask you, sir, if you've seen this photograph before.
Yes, I have, or one just like it.
Now, you've seen the socks in person, correct?
Yes, I have.
And do they appear to be inside out in this photograph, sir?
Like a magnifying glass?
Yeah.
And I've got one, but I don't need it. I honestly can't tell. If I had the socks to compare to this, I might be able to, but I don't think so. It's just heavier fabric in the heel and the toe. They certainly, the upper portion seems to be inside out, but to tell whether the whole sock is inside out or not that's lying down, I honestly can't tell you.
Nevertheless, they are lying flat on the, somewhat crumpled, but lying on the floor, correct?
One is more or less folded over. I don't know which side is up or down. It would appear that it is the left side of the one that is spread out the most that is down, but the other one is kind of wadded up.
Okay. And so the jury knows what we're referring to. I'm going to put it on the monitor. I wanted you to see it so I don't know if your monitor is going to give you as much resolution as you get looking at it up close. Now, when you said that one appeared to be more crumpled up, you were referring to the one up on top, were you not, sir?
Yes, I was.
All right. And now let me ask you a question. If you have, maybe it's just a matter of common sense, but if you have a bony protruding area on an item of clothing, like around the ankle bone, you're wearing a sock, that area is sticking out, that area would be more likely to get blood, assuming blood is in the area of the feet. Would that be a fair statement?
Yes, if it was transferred, spattering or something would be not dependent upon that, but brushing against something, yes, the bone sticks out further.
Right. So the bone area where you found that blood stain would be the place that would be most likely to receive blood from a transfer if you're in the area of blood or a bloody body, correct?
Yes, if that transfer, again, is in right on the ankle bone. I think it would make a difference whether you had it on the right or left foot, though. I think there's a slight difference, but I don't know. It's in that area. I don't know that it's at the peak of the bone, as I said. Of course, the sock is elastic, so you could adjust it so it was or it was not.
It was not. But it was in that general area, you would agree, sir?
Yes, I would.
So if that sock was worn in the commission of a murder and the feet were in the area of a bloody victim, in an area that would swipe the bloody victim, then the area where you found the stain is the area most likely to receive that swipe or compression, correct?
Forward.
I would say yes.
Now, let me ask you a couple other questions, sir. As a matter of practicality, if someone is sweating and they're wearing socks of this kind of nylon nature, as a practical matter, is it not more difficult to take socks off of a sweaty foot?
Objection, there's no foundation to call it.
Sustained.
Have you ever taken off, have you ever had,
Objection.
well, I don't know. Mr. McDonald, have you ever had the experience of wearing nylon socks and exerting yourself to the point where you were sweating?
I used to wear work socks in the oil fields where I grew up and did a lot of manual labor, but I do not honestly remember ever sweating to the point where my socks got wet, and I didn't wear dress socks in the oil fields. I don't sweat when I wear dress socks, and if I can avoid it, I never wear them.
Okay. So you've never had the experience yourself, sir, of sweating in dress socks?
Not that I can remember, no.
Well, can I ask you, sir, if in your experience you have ever had occasion to note whether wet socks or sweaty feet make thin socks like this more difficult to remove? Do you have any experience in that? So I'm trying
He's
to
asking for the foundation at this point. Do you wear these kind of socks?
No.
Men have very particular preferences about their socks. Next question.
All right, if someone has bloody hands, sir, and they attempt to take a sock off by maybe inserting the thumbs inside and the fingers on the outside, if one or more of the fingers are bloody and pressing into the sock, will that cause a compression?
Objection, Inspector, at this point.
Oral.
Well, certainly, if you have bloody hands and you touch any fabric, you can transfer blood to it.
Okay. And if you were to touch, if there were wet blood on a piece of fabric that you pressed, that would cause a compression as well, correct?
If the blood was already on the fabric,
Right. And it was wet.
you would squash the blood out of the fabric a little, laterally, yes. It wouldn't cause a transfer unless it was in contact with something else. If you're transferring it to the thumb, yeah, you could transfer it from the fabric to the thumb, if that's what you mean.
What I'm saying, though, sir, is that if there's wet blood on a surface and you press it, will you cause a compression?
If you press it, you cause a compression, yes.
And if wet blood is on a surface and you brush it, will that cause it to appear as a swipe?
Yes, it will. At that point, we would call it a swipe pattern produced by a wiping action.
And can you tell the difference, sir, between whether or not a blood drop has been dripped and swiped later? You know what I mean? Let me make that more clear. Can you tell the difference between whether or not a drop of blood is dripped onto a surface and while still wet, swiped between a blood that is initially swiped on?
If there's enough blood to remain on the surface that doesn't quickly soak right into the fiber of the fabric, you could laterally transfer it and cause a swipe pattern, yes.
In which case, what you would detect would be a swipe pattern as opposed to a drip and a swipe.
I thought I was just answering the drip and swipe. You dripped it. First of all, you're talking about just a drop of blood on a fabric. If it falls on the fabric and you very quickly create a lateral motion, you should get a swiping of that blood, which will leave blood on the top of the fibers, yes.
And then when you come to analyze it, you would see a swipe and not a drip and a swipe. That was my question.
Yes, that's correct.
Okay.
You couldn't tell the difference if it was done quickly. That's
Okay.
correct.
And the same would be true, I take it, for a compression. Is that right?
Yes, if the blood is still fluid enough, you can get a lateral motion and it would look like a swipe.
And likewise, sir, if it was with respect to a stain that you called a compression, if the blood was still fluid and then compressed with a hand or a finger, it would look like a compression to you, would it not?
Well, you just said if it was a compression, so it would look like a compression, yes.
As opposed to a drip and then a subsequent compression.
I think that would be a very difficult thing to differentiate with any degree of accuracy.
Now all right, those little balls on the surface 3, you do not know, those were not typed to determine whether they were blood, correct?
As far as I know, they never have been.
And you don't know, obviously, then,
Objection, Your Honor, that's for sidebar.
assuming they are blood, sir, you don't know whose blood they are, is that correct?
That is correct.
Now, you indicated that you determined, without ever having seen the actual piece of fabric cut out of the center of the stain, you gave us an estimate that the entire stain would have been 50 to 60 microliters of blood, assuming it was blood.
That's correct.
Okay. And that what you saw on the opposite side in terms of the little flakes and the little balls, you never attempted to quantify, is that right?
Other than to say there was an extremely small volume, no.
It's asked 3 times.
Actually, this is the 4th time. You're right.
All right, so let me ask you a few questions about your background. Do we have to quit exactly at 4?
Yes, we do. We have a doctor's appointment that we have to keep.
Oh, that's right, that's right, that's right. All right, would you like to break now then, Your Honor? And I have one very short area that I intend to complete tomorrow. I won't be able to complete it before 4 o'clock.
Once you finish what you can.
Okay. All right, sir, you stated that you were a professor of chemistry at Milton College in Wisconsin for a period of time.
Yes, I was.
Yeah, is that college now closed, sir?
Yes, it is.
When it was open, it was a small liberal arts college, is that right?
That's correct.
About, what, 350, 500 students?
I don't think they ever had 500 while I was there. More like 250 to 300, I would think.
Now, let me ask you, at the time that you became a professor, you had an undergraduate degree, correct?
That's correct.
And you became the head of the Department of Chemistry at Milton College, is that right?
That's correct.
Now, when you were head of the department, sir, the entire chemistry department consisted of who?
Me. I was it. I replaced 2 people and offered 12 courses.
Okay. Did you give yourself assignments?
I gave a lot of assignments.
I mean, as head of the department. That was a joke. All right. Did you taught criminalistics at Elmira College in New York?
Yes, I did.
And you left there in 1983, is that right?
That's correct.
Okay. You said adjunct, but that's a part-time professor, is that right?
Part-time rank of full professor. I believe they have adjunct, associate, adjunct, assistant. It varies from one school to another.
Okay. So what were you teaching at night, sir?
Yes, I was.
Was that a continuing education course you were teaching?
Continuing education courses. I taught quite a few.
Okay. Was that 2 to 3 days a week?
It depended. It was usually 2 nights a week, and 2 nights a week every semester, and the summer.
You taught one time at Corning College, is that right?
For quite some time, Corning Community College.
Okay, that's a 2-year college, is that right, sir?
That's correct.
So they don't give any degrees other than AA.
I'm not sure about that. I think they have, since I left, negotiated some form of getting a 4-year degree or a master's program through John Jay College in New York. I'm not sure about that, but basically it's a 2-year school, part of the State University of New York.
Okay, and again, there you were teaching part-time?
Yes.
And was it night school again, continuing education program?
It was days in the beginning in 1960, and then it went through different transitions and ultimately ended up in the evening program, yes.
And was that, again, 2 to 3 nights a week?
It varied depending on the semester, but 2 nights a week was the most I could do.
Now, with respect to either Elmira College or Corning, sir, would you say that either one of them had a formal forensic science program?
They did at the time. They had a criminal justice program at both places. Department of Criminal Justice, I think, was what they called it. They also had a forensic science certificate.
Okay. But when I say a formal forensic science program, sir, I'm talking about something akin to formal program for the giving of a degree in criminalistics or forensic science.
They gave a degree with a major in criminal justice. I don't remember the exact title of it. That's
But-
what it was.
Okay. The criminal justice program, sir, is like the administration of justice, isn't it?
Well, that's part of it, I guess, yes.
It is not primarily a science program, is it?
No, but it satisfies certain science requirements, or at least it did.
It's primarily a coursework, a study of coursework that deals with the criminal justice system, isn't that right?
In general, but my work was primarily in the forensic area of physical evidence and crime scene investigation and microscopy and so on.
Here, sir?
Yep. All right, ladies and gentlemen, we're going to take our recess for the afternoon session. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. Take care of yourselves. Stay well. If there's anything we can do in that respect to help you out, let us know. All right? Get plenty of exercise, fresh air. See the doctor when you need to see the doctor. All right, as far as the jury is concerned, we'll stand in recess until 9 o'clock. After we clear the courtroom, we'll get Mr. Bosco's status report. And, Professor, we'll see you tomorrow morning, 9 o'clock. The jury is not present. We needed to take up the Bosco matter.
I know, Your Honor, I'm just wondering whether or not there's two housekeeping matters with regard to the last witness that I can take up before you get into
Sure.
the Bosco matter. Thank you.
Before we do that, John, let's talk about the courtroom.
Okay, well, summon her back.
Thank you. I'll wait until she comes back.
All right. All right, I understand we have counsel for Mr. Bosco, Ms. Osinski, and Mr. Sullivan, correct?
That's correct, Your Honor.
All right, good afternoon. Counsel, would you state and spell your names for the record, please?
Yes, Your Honor. Last name is Sullivan, S-U-L-L-I-V-A-N.
Your Honor, Helena Osinski, first name is spelled H-A-L-I-N-A, last name O-S-I-N-S-K-I.
All right, good afternoon, counsel. Thank you for making yourselves available on such short notice.
Good afternoon, Your Honor. At this time, we've just been retained, and we have not even had a chance to speak with our client, Your Honor, because he has been in the courtroom. We would like a little bit of
Take
time.
him out of the courtroom.
We would like a little bit of time, because the Shield Law is involved in this matter. We'd like a little bit of time to be able to brief it and then to have a hearing on the matter. It's at the court's disposition as to when you would like to hear this matter, but can we put it over to another day as opposed to this afternoon?
Sure. How much time do you think you need?
Well, we'd like to submit something in writing by tomorrow and maybe be heard after the court session on Wednesday afternoon. Would that fit in with your schedule,
See, I
Your
think we
Honor?
have the continuation. Would you be available tomorrow at 4 or 4:15?
We could, Your Honor, yes.
That'd be fine.
Okay. 'Cause- all right. And Ms. Osinski, Mr. Sullivan, have you had the opportunity to confer with Mr. Shapiro regarding the issues that they seek to raise with your client?
Just very briefly, Your Honor, we've just...
All right, then I'm
very
going to
briefly.
direct counsel as soon as we break on this issue then to confer, to meet and confer and see if there's any narrowing down that we can do of the issues involved.
Thank you, Your Honor.
All right, is there anything else that we can take up as to the Bosco issue? All right, I've been provided with, counsel, do you have a copy of the article that's referred to?
Your Honor, we don't have a copy of the article or a copy of the subpoena. We have nothing.
Okay.
I did a copy of Mr. Morrell, so I'll write another copy.
Okay.
All right, I think my staff has a copy of the article in question.
Thank you, Your Honor.
All right.
Your Honor, while we're waiting for Ms. Clark, I think we have to resolve the scheduling problem now with tomorrow. I'm assuming that Professor McDonald will certainly be finished within an hour tomorrow morning. It was our intention to call, if not Tracy Savage as the next witness, certainly Michelle Kessler. However, Michelle Kessler, at least tomorrow, we'd like to resolve the 402 issue as it applies to Tracy Savage. As was pointed out to you by my colleague, Dean Ullman, we wish to add to the hopper, if you will, for your thinking about the various factors, Michelle Kessler's outside the presence of the jury testimony on that limited issue.
Okay.
There was some mention that she has an appointment, or she has, I think, a funeral or something in the afternoon. So perhaps we could do at least the outside the presence of the jury portion of her testimony earlier tomorrow. But we do not have another, and we can play the Paratus tape, but that doesn't take up much time. But after that, our next witness is Dr. Gerdes, and we're not ready yet with Dr. Gerdes. We'll be ready with him by Wednesday morning, but we are not ready. We were planning on having these other witnesses Monday and Tuesday.
I'm just thinking, I can't believe, although I've been wrong before, that Mr. McDonald will take up the full morning session.
No, I think you're right, he won't. Ms. Clark represented that she only has a few minutes, I believe.
All right.
Your Honor, is the court aware that Michelle Kessler is not going to be available until probably late tomorrow afternoon? She was attending a funeral.
No, I'm aware she has a funeral obligation in the afternoon. What's her status in the morning?
Well, I think she's leaving for the funeral and will not be available after 11, and then will probably be available again after 4. What's her best estimate?
Since her testimony, at least to make out this offer, should not take more than 20 minutes.
How about if we start with her at 9? Do that out of the presence and
Right.
bring the jury down. That sounds like the best way to do it.
Right.
Well, Your Honor, the other possibility would be to require counsel to make an offer of proof as to what she's going to say, or they think she's going to say outside the presence of the jury that would be relevant to the issue as to
I think we've already gone over that, though. If you recollect, Mr. Goldberg, this morning we were just sort of thinking out loud that Ms. Kessler could testify to any inquiry that was made of her, any knowledge that she has, or any action that she took regarding leaks. I mean, there are things that as the then acting head of the laboratory and now the head of the laboratory that she can speak to with regards to this issue.
Well,
So I'm convinced that there's enough to at least ask her some foundational questions with regards to these issues.
What Your Honor might not be aware of is that counsel did speak to Ms. Kessler at length, so they know specifically what she would say and the extent of her knowledge on any of these issues, which is
Well,
very
that's not the
limited.
point, though, Counsel. The point is that for me to go further on the Tracy Savage issue, they want to offer more evidence with regards to the materiality of the issues concerned. And maybe I misunderstood the comments of other counsel, but I consider this to be a very serious and very sophisticated issue. So there.
We'll do that at 9 then?
So why don't we take that up at 9? I assume, Mr. Allman, we're talking about a relatively brief direct examination, 20 minutes or so.
Yes, actually, Mr. Neufeld will conduct it, and it should take no more than 20 minutes.
And I have to do that because if it's any longer, I have to deal with Professor McDonald, who's already been out here 3 times, and I assure the court that that's what we're talking about.
Okay.
Right.
All right. All right, so tomorrow we'll take up Michelle Kessler first. We'll finish with Mr. McDonald. We'll play the Thano Paratus tape. And then if we haven't resolved the Tracy Savage issue yet, then we may run out of witnesses. But even if we have the Tracy Savage issue, well, I don't know how long that could take.
There is another issue that Your Honor may be able to resolve today. In addition to the tape, we would like to present the Thano-Paratus grand jury testimony. I don't know if that has been resolved.
No, that hasn't been offered formally to me. It's been mentioned, but nobody has cited, nobody has argued the admissibility or non-admissibility of the grand jury.
We can do that now.
All right.
Well,
No, we need to discuss one other matter. All right, let's finish Mr. Neufeld's. Do you need to go?
okay, then let's take care of this now then.
All right.
There are 2 items. One is, in front of the jury, Ms. Clark erroneously represented to this jury that the prosecution did not receive the notes of Professor McDonald from the April 2nd visit and inspection of the socks. That was just flat out wrong. I'm not going to attribute a motive. I have no idea what was in her mind, but it's flat out incorrect. I have given the court a signed copy of an acknowledgement of receipt of discovery signed by Mr. Darden on July 17th, 1995, in which, if you see, item number 3 on that sheet are the laboratory worksheets of Herbert McDonald dated 4/2/95. In fact, when the report was typed by a member of Mr. Cochran's office, she mistakenly said there were 2 pages of notes. When Mr. Darden looked at the notes, he observed that there were 3, and so he crossed out the 2 and he wrote in the 3. The 3 pages of notes were inspected again by Ms. Clark this afternoon. She has really, I mean, I think it's just completely inappropriately tried to prejudice Mr. Simpson by suggesting to this jury
Sanctions.
that the defense did something tricky in not turning over those notes. The notes were turned over. There's no question they were turned over. If by chance Mr. Darden didn't get them to Ms. Clark or Ms. Clark may have misplaced them, I have no idea whether some inadvertent mishap occurred. But the bottom line is those notes, the very same notes that he just showed to Ms. Clark during the cross-examination, were turned over to Mr. Darden on July 17th, 1995, and he signed for them. And I believe, Your Honor, that at this point in time, what has to be done is this jury has to be told specifically that that was erroneous, that in fact those notes had been turned over on July 17th. No, it's July 17th. Those notes have been turned over on July 17th to Mr. Darden, and that he signed for them, and there is a receipt to prove it. I would ask for that. I would also ask, in addition, Your Honor, that because I think to make that kind of remark in front of the jury is incredibly reckless, and is a reckless disregard for the truth when she should know better, that it warrants a monetary sanction as well from the court.
How
And
much do you suggest?
I suggest $250, Your Honor, which was the last sanction she received. I also suggest a sanction, Your Honor, against Ms. Clark for having blurted out or attempted to blurt out that she was impeaching Professor McDonald with a case after, before direct examination, we set ground rules, Your Honor set ground rules, that she was not allowed to mention any cases at all without first approaching for a sidebar. That warning was reiterated this afternoon, just before I completed my direct examination and Ms. Clark began her cross-examination. And Your Honor affirmed that to her. She knew it darn well, and she ignored it, having been warned twice. And I think that also warrants a sanction, Your Honor. The amount of which I can leave up to the court, but I think...
Well, let me ask you this, Mr. Neufeld. If you recollect when you brought that matter up at the sidebar, and if you recollect, I'm the one who I think invited us over there in the first place, I indicated that I would take that matter under submission, the request for sanctions, once I saw the testimony, saw what it was, and determined how bad a violation it was.
Right.
And do you want to expound upon how bad a violation you felt that was and what the damage was to your client as a result of that?
Your Honor, the only point I would make is there was a suggestion, just by bringing up a case and her remark about, well, didn't you testify in this case that? And then she mentioned the name of the case. There was an inference that she was in fact asserting at that point that he was somehow testifying differently here in court than he had been in some other case. Number one, that's not true. Number two, you looked at the transcript, in fact, that she was referring to and saw that one had absolutely nothing to do with the other.
No, he said the same thing. He said it's tough to see blood on dark fabric is what he said.
Well, that's what I'm suggesting is by her then trying to say to him, isn't it the fact that you said something in this case, she didn't get a chance to actually get out what it was because that's when you cut her off and asked for a sidebar. But the jury is left with the impression that either it's a more extreme statement or it's a different statement. It's something other than what the witness articulated from the witness stand. That's the whole point of trying to then refer to someone's testimony in another case. Otherwise, it wouldn't be brought up because it wouldn't be impeachment. That's how lawyers get to refer to other cases. The jury by this time is already primed because it's been a technique utilized by lawyers on both sides for impeaching witnesses. That when they hear the person start referring to some other case in your testimony, they believe they're about to hear impeaching contradictory testimony, which they didn't hear here. Granted, it is not the most substantial act of misconduct on the part of the prosecutor in this case. I'm not asking that the court treat it as such. But I do believe that in terms of your own desire to be even-handed and to maintain order here, that if the prosecutor had been warned twice not to do it, and did it anyway, that some type of sanction is appropriate. I think, frankly, what she did vis-a-vis the notes is a far more serious matter. Because it did, there's no question in my mind that it does immediately and directly prejudice Mr. Simpson, and certainly Mr. Simpson's lawyers, by suggesting that we, by trickery, didn't turn over certain notes that we were required by law to turn over, when in fact they had been turned over.
Ms. Clark.
I've never seen the law practiced this way, with lawyers asking for monetary sanctions against the other side. Never. Never. I am dismayed, and I'm embarrassed, and I'm ashamed of my profession when I see it practiced like this. I would never ask for a monetary sanction to be imposed against any member of defense counsel. Not one. That's for the court to do if the court deems it appropriate, but I would never ask for such a thing.
I think she did.
And I think Mr. Neufeld should be ashamed of himself. Now, with respect to the discovery violation, Your Honor, I was deceived. The witness referred to notes. I've never seen any notes. I didn't know what he meant. When he said notes, what he actually meant was simply a document that introduced the fact that he had received the evidence at a certain point on a certain date, described what that evidence was, and then 2 pages of diagrams. He called those notes. I didn't know that. When I say notes, I think of written documentation like Dr. Lee made, detailing observations of what he saw. There was no such thing. Now, when he said notes, I was surprised, because I did not characterize what he had as notes. When he showed me what he had, I realized that the first page on which he had writing, I had never seen. Never seen. So as far as sanctions go, which goes to good faith or not, I had extremely good faith. I had never seen that before. Nevertheless, I didn't make a big deal about it, quite the contrary. What I did was to minimize it in front of the jury and point out the fact that those quote-unquote notes are nothing more than 2 diagrams and a description of the evidence and the date he received them, and he agreed that that was so. And we further pointed out that those quote-unquote notes made no characterizations of what he saw, did not detail his observations or his conclusions, or any observations that he made of the socks or anything that went on. So it is appropriately before the jury, accurately, exactly what that is. Talk about de minimis, that is very de minimis. Had the witness not characterized something as notes, which I would never have characterized in that manner, that exchange would never have occurred. I was taken by surprise. I had not seen that first page. I don't consider it a big deal. now that I see what that first page is, and that is why I didn't ask to approach and ask for sanctions against counsel at that very moment. I could have. I could play the same game they're playing, and every nitpicky little violation, I demand sanctions, and I demand they be put in jail, and I demand they be held in contempt. I don't do that. I don't need to do that. I can just practice law. I can just try my case without playing these little games here about nanny, 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 and neener, neener, and who's got the last sanction, who's going to pay money this time. This is sickening. You know, what we've descended to in this case. That Mr. Neufeld stands before you because the witness characterized something as notes that no one else would so characterize, and because I'm taken by surprise by that, then question him about it because I see something I've never seen before, and stand before you and say that deserves monetary sanction. First of all, those words should never leave his mouth. Second of all, to make the mountain out of the molehill that this is ridiculous. But I was taken by surprise by the witness's characterization. The page I saw I'd never seen before. It has now been accurately assessed in front of the jury, and I don't know what kind of impact the defense would like to have, but I can guarantee this court that I will bring out with questioning from the witness that the two diagrams that he referred to I had seen before. And if the court wants me to further inquire of the witness whether, or stipulate that that was turned over, that one page of document receipt, I've never seen it, but if the court wants me to indicate to the jury in some manner or stipulate that it was turned over on July 17th, I will do so. I don't have any problem with that, but a sanction? I mean, I think that we have really gotten into the outer limits here. With respect to the case that was cited, Your Honor, that case simply cited in support of what the witness was saying. And it was very clear I wasn't impeaching him. Because what my statement was, as I recall it, is that he said, yes, it's difficult to observe blood on dark clothing. And I said, yes, and didn't you so testify in the case of People versus Briggs? Totally consistent with what he said here. It was corroborative. And I wanted to discuss with him the circumstances of that case as by way of analogy. Of course, precluded me from doing it so far, but I think it's relevant because he went to some lengths to try and visualize the blood for the jury because of the difficulty they would have in seeing it. And I think that's an important point to make. He didn't do that in this particular case, but it could have been done. In any case, that's all it was. It's corroborative of him, not impeaching of him at all. So what is the damage done there? There is none. I inadvertently forgot to approach, and had I intended to impeach the witness or do something damaging to his credibility with it, I think it would have occurred to me sooner to approach. However, in light of the fact that it was simply corroborative of what he was testifying to, I didn't see this as a harmful thing, and counsel concedes.
Do you recollect being directed on at least 2 occasions that if you were going to refer to a transcript, that before you did so, you were to ask to approach so that I could rule upon whether or not it could be used for that purpose? Do you recollect that?
Yes, I do, Your Honor. I do. And I should have done that. And I simply forgot. And as the court recalls, I did do so on a subsequent occasion with respect to another case. But I forgot. I forgot. This has been a very contentious bit of testimony. There's been a lot to be concerned with and a lot of argument back and forth about what the witness can testify to and what kind of questioning is going to be permitted. And so I forgot. I'm human.
All right, thank you, counsel.
Your Honor.
I'm sorry, hold on a second. Mr. Darden, do you acknowledge that you received a copy of the 3 pages of Professor McDonald's worksheets that were dated April 2nd?
All that I can do is this, Your Honor. Whenever I'm given or provided discovery by the defense, I look at the documents, I count the pages. I don't know that, I don't recall what the notation is on this document.
The judge has the original. Here you go.
It's the 3rd item.
What I see is laboratory worksheets of Herbert McDonald, page 4295, 3 pages. When I heard the witness say notes, I do recall having seen the notes. I didn't equate his use of the word notes with lab worksheets. But I count the pages and I look at the documents when I receive them from the defense. And so I certainly received a 3-page document relating to the witness's lab work as they related to the SOC. And I would indicate this as well. Once I receive these documents, I hand those documents to a law clerk. Okay, I don't keep them here in court. I turn them over to a law clerk immediately so that they can be documented as having been received upstairs. They're supposed to be circulated to Ms. Clark and myself. That does not always happen.
I don't know,
So,
Mr.
I don't know.
Darden, if I were a trial lawyer who had the job of cross-examining an expert witness from the other side, I would certainly want to see every note that was ever produced or anything that had been produced by way of discovery.
That's absolutely correct, and I agree with you 100% in that regard.
So
But
doesn't this sound to you mildly implausible?
Well, Judge, if you look at the 3 written on that paper, I believe I'm the one that wrote that 3. I corrected the 2 pages, so obviously I'm paying close attention to that. But there are 40,000 pages of documents and transcripts and other things in this case. We assume that we get everything. I am often surprised to find additional things, like some stuff I found on Christian Reichardt just Friday. I was amazed to find that. But it'd been up in upstairs for weeks. It happens. I just don't think that every violation is warrants this type of reaction from the defense or a reaction from the court. This is litigation, and these things happen. I mean, I've seen Mr. Neufeld approach witnesses on direct with documents he's never shown us. I mean, it happens. It just happens.
All right.
Your Honor, just two very brief remarks, if I may, please.
Two.
Okay. One is, she chose to make it an issue in front of the jury. She could have, at that moment, asked to approach a sidebar and didn't do that. And I think that exacerbates the whole problem.
Well, I have the transcript of the entire discussion, which goes on for all of 3 lines. It's not a huge discussion.
I understand that, but there was still, the suggestion was made in front of the jury, and it didn't have to happen that way.
That's correct.
And
I
this,
agree with you that the assertion that the notes had not been turned over is clear in the record and is incorrect. I agree with you 100%.
okay. And the second thing, Your Honor, is, look, I agree that perhaps lawyers shouldn't be asking for monetary sanctions, but Ms. Clark's memory is somewhat failing her on this point, because she, on more than one occasion, had sidebars for the volume of my voice was suggesting that the court impose sanctions against me. And, Your Honor, I just feel that perhaps I reacted to her and what she did here because of the suggestions and her request for sanctions against me on earlier occasions. And she's right that it is sad that has to be the situation.
Hell no, T. Everybody around you ends up in the hospital. I'm not going to your house. I'm just glad you're not in the hospital. That would suck. Did you lose the chat on the screen?
It is in that
Hold
context
on,
that I
let
made
me
that
look.
remark, Your Honor. The only other thing I had to say,
see
Your Honor,
it.
about the other aspect, which was the referring to the case.
Is
I
it
think that
not
the fact that it
refreshing?
didn't impeach,
All right, hold on.
and she knew it wouldn't impeach, makes the blurting out of the case all the more inappropriate. Thank you.
If you must.
I refreshed.
This goes to the expert's opinion and the fund of knowledge that he draws on for his expertise. And so prior casework that tends to corroborate or support his opinion is fair grist for the mill in cross-examination of an expert. He
But
had
the
this
problem is,
experience.
I don't care so much about that. I agree there are many things that you can cross-examine an expert about, his or her qualifications being a very broad area. I agree with that. I think you could have more obliquely approached that particular area regarding the difficulty of seeing blood spots on dark materials. That's not the issue. The issue is the court's direction to counsel that before any transcript was to be used, that you were to approach sidebar and ask for direction from the court. That's the problem. What I can't do at this point is, I've apparently used the wrong word search inquiry here, and I keep coming up with the wrong sites to the transcript. I want to review exactly what was said, the context in which it was done. At the very least, tomorrow I'm going to instruct the jurors that the inference that the notes had not been turned over was in fact incorrect, that they had in fact been turned over in a timely manner to the prosecution, and that the jury should disregard any negative inference to Mr. Simpson and his defense counsel. Secondly, I'll take the matter of monetary sanctions or other sanctions under advisement until I've had the opportunity to check the transcript. All right, anything else? Yes. Anything else?
Grand jury, you want to do that now?
Yes.
For the record, I never asked for Mr. Neufeld to be sanctioned because of the volume of his voice. The court will recall when that occurred.
I think that was my idea.
Your Honor,
Yo, that is
But
so
in any event,
good.
let's not, no, this issue's
That
over.
is
This
so
issue's
good.
over unless both of you want to get sanctioned without any recourse to the transcript.
Sanction them.
All right, grand
Sanction.
jury testimony. Mr. Ullman.
I think we can handle this quite briefly, Your Honor. The defense trial brief dated July 20th with respect to the admissibility of the former testimony of Thano Paradas addressed the question of both the testimony before the preliminary hearing, of which we have a video of his testimony, and the testimony before the grand jury. The authority to use the grand jury testimony comes directly from Section 1291A1 of the Evidence Code. The former testimony exception really creates two exceptions. One, the former testimony is offered against the person who offered it in his own behalf at the prior proceeding, or, subsection 2, the party against whom the testimony is offered had the opportunity to cross-examine at the former proceeding. The first exception does not require that you even have an opportunity to cross-examine, because it is based on the theory that your presentation of the testimony as direct testimony is a substitute for your opportunity to cross-examine. And we cited the Salas case, which is really the leading case interpreting Section 1291. It's an opinion by Justice Bernard Jefferson, who is the author of the bench book on evidence. And in Salas, he was presented with a rather unique situation where the prosecution was offering preliminary hearing testimony that had been offered by the defense at the preliminary hearing. And he noted in the Salas opinion that under subdivision A1, a party's previous direct and redirect examination called by him on the prior occasion is justifiably considered to constitute an adequate substitute for such party's present right to cross-examine the declarant. So we didn't call the witness at the grand jury, the prosecution did. So their presentation of his testimony before the grand jury as direct testimony then justifies use of the 1291A1 exception to now offer that testimony against him.
Mr. Goldberg?
Oh, I made a short of that
Your
one.
Honors,
Zach, I
recall
didn't
that
watch
the
it.
defense
I didn't
called-
see you sneak in, Zach. I'm so sorry. I just like 5 minutes ago released a short of that Elmore one, but not the whole thing. Yeah. When he leaned forward in his bench, whoo.
The witness as their own at the preliminary hearing, and the prosecutor then wanted to use the transcript of the trial, and they held that it could, so it's slightly distinguishable, although I don't necessarily disagree with counsel's interpretation
I think you
of the
should still
overall
go.
importance of the case or the evidence code per se, although we haven't found any cases that specifically say that grand jury hearings are admissible. Usually we've seen depositions introduced in cases where the declarant is unavailable or preliminary hearings. So while not conceding the issue, only because we don't have any dispositive
Although he was in the hospital for Thanksgiving. You know how I usually tell you to steal his Jell-O? I would have told you to steal way more on Thanksgiving. Let me tell you.
case law, it doesn't appear that counsel's interpretation of the law that we do have is fundamentally unreasonable. What I would like to draw the court's attention to, however, on the issue of the admissibility of the transcript testimony is that previously the people filed a brief discussing if Thanoparatus were to be called, at the time that we thought that he might be called as a witness, the extent to which his statements concerning the amount of blood in the blood vial would be admissible. As the court will recall, when Greg Matheson was testifying on the same subject to trying to estimate the amount of blood in the blood vial, or that would have been consumed during various transactions, the court required the people to lay an extremely thorough foundation as to how those figures were arrived at. And in fact, he never really was allowed to testify as to approximately what quantities would have been used during certain transactions. The people could only get that testimony in by having him repeat those transactions during the evening, and then the morning following repeating those transactions, testifying to the actual amount of blood that was used as opposed to an estimation of the amount. So the court has in essence heard that even an expert witness cannot offer estimations as to small quantities of blood that were involved in particular transactions with the blood vial in question in this case. We feel that the same rulings are equally applicable with respect to Mr. Paratus, only even more so, because in fact there is no foundation for how Mr. Paratus arrived at his estimation, and there is no foundation for how he calculated the amount of blood. In fact, we've talked to him since then, and he said that this was purely an estimate.
I can't make a pecan pie early. I don't have it in me. I'm not strong enough. I'm weak. I'm so weak. That pie would be gone before Thanksgiving, and then I'd be like, oh shit. I gotta protect myself from me on this one.
The same rules that the court applied to Mr. Matheson, that testimony should not be permitted.
Did
Now,
he testify it was approximately 8 milliliters? Is that what he testified?
well, at first he said approximately 8 milliliters, and then he was asked a clarifying question, what does he mean approximately 8? And he said between 7.9 and 8.1. Now, of course, as Your Honor knows, just by looking at the blood vial itself, it would be humanly impossible to, with that degree of precision, determine the difference between 7.9 and 8.1. So how he came up with those numbers seems to defy common sense when one looks at the fact that this is not a calibrated blood vial.
No, it's marked, my recollection is it's marked on the side of the tube, 10 ml, it's purple top.
The purple top tube is not calibrated.
No, I know it's not calibrated. I'm just saying that the label itself is, they're 5 ml purple tops and they're 10.
This is what's been, I don't know if it actually says 10 mLs on it, but everyone has been under the assumption that this is a 10 milliliter tube, and I believe Mr. Matheson testified to that.
Right.
He said that that was his long-time assumption. In fact, I think the tube actually has a capacity of 12 milliliters. I don't know if that's really all that significant in terms of the court's ruling here. But the point is that there is no adequate foundation and can be no adequate foundation for this kind of testimony. Now, as I'm sure Mr. Ullman will also agree, because I know that he's researched this part of the law as we have, even if a party did not make those substantive objections at the time of the preliminary hearing or grand jury, we do not waive them.
Guys, we need to stop about Thanksgiving, and we're not going to. I know we're just going to keep going. I'm sitting here watching OJ trying to calculate exactly how much turkey I can eat, how much mashed potatoes I can eat, and still be able to have three slices of pecan pie. How much dressing I can eat, stuffing for people who don't say dressing, gravy. I mean, I'm trying to mathematically calculate what I can skip. I don't really need that bread. Oh, but it's so good. I don't really need that corn. Oh, I should eat a vegetable. To make sure that I can eat as much as I want to on Thanksgiving. Remember when we were all 18? And we could just eat 3 plates and just go about our day like nothing happened to us? Remember that? 1 bottle of wine, 3 plates of food. We just go off into the sunset. Now I have to plan. I'm going to have to get charts and graphs and crayons.
And can remake those objections at the time that the testimony is introduced in the form of a transcript. The only objections that are waived are objections that go to the form of the testimony, but not any substantive ones, such as lack of foundation. An objection that something is leading or suggestive would be waived if not raised previously. But all of these substantive objections would remain. So if we could imagine Mr. Paradas testifying in court and being asked how much did you draw, we would object no foundation. That objection would be sustained in light of the court's rulings with regard to Greg Matheson. And I don't think it's an objection that the defense could ever overcome. So that portion of his testimony, if the defense wants to introduce the transcript testimony, should be stricken. And then the remainder read to the jury.
I save the court time on this. I think I can. This is completely misrepresenting and misleading as to what Dana Paradas testified to. He's not relying on the
Sanctions.
test tube, right? He says, I drew 8 cc's. How did you know how much it was? He says, I just looked at the syringe, and it looked to be about 8 cc's. I saw the syringe in his office. The syringe is calibrated by cc's. Okay, that's how one does it. He didn't rely
38.
on looking at the test tube after all. He looked at the syringe. That's a sworn testimony at the preliminary hearing. That's a sworn testimony in the grand jury. He is not just an expert, he's a recipient witness. He's simply saying, I drew blood, I looked at the syringe, and it was 8 cc's. Was it exactly 8 cc's? No, it could have been as little as 7.9 or as much as 8.1. It comes in for that. And I would add one other point at this time, Your Honor.
Your Honor,
Mr.
don't you have a one-attorney rule here?
Well, Mr. Ullman was actually addressing the admissibility of grand jury testimony. He then brought up a second issue, which is that none of it should come in, not because it's not grand jury testimony as opposed to preliminary hearing testimony, but because we can't lay a foundation. Since I was the person who was going to put on Mr. Paradas, as you may recall, and the person who had made the motion to strike their testimony.
All right, but I consider this to be a waiver of any other argument on the other issue. All right.
Dan, as young as you think Josh is, he's younger. Just, I had to get over that fact a long time ago.
Proceed.
Okay. They are suggesting that he has said something to them subsequently in time about his testimony in the preliminary hearing in the grand jury. Number one, when Mr. Goldberg had the argument last week on this issue, he actually suggested there were prior inconsistent statements. We know of no prior inconsistent statements made by Mr. Paradas which would contradict his sworn testimony at the preliminary hearing in the grand jury. More importantly, Your Honor, at this point in time, we have not received a single statement in discovery from the prosecution, a written statement of this witness, an interview with this witness, an audio tape of this witness, a videotape of this witness. We've received absolutely no discovery at all that contradicts what Thano Paradas said in sworn testimony both in the grand jury and at the preliminary hearing.
But here's the problem. They have, Mr. Paradas is on your witness list, and they have prepared, apparently, to impeach that testimony. Under the rules of discovery, since it's direct impeachment, they may not have to turn that over to you. All right, but...
So he was on their witness list, Your Honor. That's what I'm informed of. Initially, they just chose not to call him.
He's on yours now.
Well, I understand, but if they had some statement from him before they rested their case, when he was still on their witness list, we should have received that statement, or it's a discovery violation.
All right, counsel, thank you for another entertaining afternoon.
Sorry, Your Honor,
No, I've heard enough, guys. Thank you. All right, I'd have previously, and if I haven't formally on the record, made a finding of unavailability of Mr. Paratus. We will allow his prior testimony from the preliminary hearing. Likewise, I believe that 1291 does also allow for the presentation of the grand jury testimony. As to the foundational objection that Mr. Paratus is not competent to testify to the amount of blood that was actually drawn, the court will overrule that objection. Paratus' testimony at the preliminary hearing was that he's been a jail nurse or a registered nurse for 20-odd years, and that drawing of blood is a routine thing that he does, and that I assume that there'll be some other foundation later in the record, and I'll allow this testimony subject to that later foundation that calibrated syringes are used for the purposes of drawing the blood, that the purple top tubes are the type that are marked. My recollection of the photograph that I saw, it's marked 10 ml at the bottom of the tube, is the type that was used in this particular case, so the objections are overruled. All right. All right, we'll be in recess at 9 o'clock. Mr. Simpson is present before the court with you as counsel. Mr. Shapiro, Mr. Cochran, Mr. Ullman, Mr. Blazer, and Mr. Neufeld, people represented by Ms. Clark, Mr. Goldberg, Mr. Darden. Jury is not present, and the jury is up in the holding lounge upstairs. And I recollect that I saw Michelle Kessler this morning come in with a city attorney.
Sanctions?
All right.
Did he look at the transcripts?
All right, Mr. Cochran.
Good morning, Judge Ito.
Good morning, sir.
Your Honor, one matter I wanted to bring to the court's attention to perhaps get some clarification. Yesterday, the court asked Ms. Clark whether or not she could establish a foundation, as I recall it, for some alleged videos of our client with gloves, which we had seen in the past. And Ms. Clark smiled at Your Honor and said, absolutely. And we were informed that yesterday, after court, Suzanne Childs of the District Attorney's Office called various members of the media that said Ms. Clark had been misquoted or had been misunderstood regarding their ability to lay a foundation regarding these items. And as officers of the court, I'm just rising to try to get a clarification of what is true and what was meant by what Ms. Clark said. If there's some misunderstanding, we have a right to know that, and we want to know exactly, and you have a right, obviously, to know what was meant. If they're backing off, you read the LA Times today, you'll see some mention of that, I think. And I know that's, forgive me, I forgot who I was talking to. You've not read the LA Times, right? But anyway, Your Honor, I think
No,
this
it's not out of disrespect for the LA Times, but I found that it's not helpful for me to read news media reports of this case, because I don't want to be influenced by any of them.
I understand, Your Honor, certainly. We share that view on occasion ourselves. Your Honor, but at any rate, I rise to ask for clarification of whether Ms. Clark
Liar.
foundation, these
Liar.
are similar, or these the exact same gloves. The information we got, and much of the media got, well, these are going to be the same gloves, and we know that's not true, so I think we should have some clarification of that, and I want to do that early on.
All right. Good morning, Ms. Clark.
Good morning, Your Honor. I don't try my case in the press, and I don't read the papers to see how I should respond to counsel in court. I think it was very clear to the court what was meant, what I said, and I think that's all that matters. What the LA Times thinks about what I said or any other reporter is irrelevant to me. The court understood me. The court questioned us at sidebar. I don't think there's any misunderstanding between the court and myself or counsel, and I don't think any further clarification is required.
We did discuss this matter twice, once in open court and once at the sidebar. And at the sidebar, my recollection is that we discussed the nature of the stitching and a few other...
Well, if I might...
And may I add one more thing? Yeah, just a minute.
Yes.
One more thing is that whether or not counsel puts in the glove drying experiment, the people's position is that those gloves and those photographs photographs of Mr. Simpson wearing those gloves will be relevant on rebuttal, regardless of what the defense does with respect to experiments or not, because they are relevant to disprove the conspiracy theory. There are many reasons why those glove photographs will come in rebuttal, we believe, regardless of whether or not they come in during the defense case. This was simply one chance to put them in during the defense case. There may be others, but if there are not, on rebuttal, to
that's
refute the
great,
conspiracy
Val.
theme and to
That's
refute
great.
the planting theme that the defense has throughout carried in this case, I think
So
they are.
I take it the bottom line, Ms. Clark, is that you stand by your statements on the record of yesterday.
Yes, Your Honor, I do.
Well, that's fine then, because the only thing I want to point out, when Suzanne Childs, who represents that office, makes calls saying she was misquoted, I think we have a right to inquire upon that, and that's all we've done, Your Honor.
I understand that.
We vigorously dispute that. They will never be able to prove these gloves. Our client wore those gloves, and you'll see. And then the last thing I'd like to say is that we've opened no doors on this. If they had this information, Judge, they would have put it in their case in chief. They didn't, and we'll vigorously oppose any attempt and rebuttal at that time.
All right, and just for counsel's information, late yesterday I received from the FBI a package of photographs and videotapes regarding shoes and gloves that my staff is cataloging right now and will make available to you
Thank you.
later this morning.
Thank you.
All right, let's proceed to the Michelle Kessler issue. My understanding is the defendant wishes to call Ms. Kessler to testify first to the normal things, that she's the lab director, that she did participate in the inventorying of all of the evidence that was in possession of the LAPD at a certain point in time. Did other
Remember
things
her?
with regards to the
Remember her from the preliminary hearing? She's like the head of the LAPD crime lab. I can't remember her name, but remember her? She was the one when they said they were going to give like 2 of OJ's hairs to the prosecution. She's up there saying, "Well, no, we need 10 from this area, 10 from this area, 10 from this area, 10 from this area," and the defense is Johnny Cochran's like, "No, we'll give her 1 or 2 hairs," and I think Ito said that she was allowed to have like 12 hairs or something. Yeah, remember that was a long time ago.
physical evidence itself, and then there are the other issues regarding leaks of information. All right, so those 2 general areas, I understand, is what we're going to inquire into. Is that correct? Mr. Neufeld, are you going to handle this?
Yes, Your Honor. I don't even intend to spend that much time on her inventorying and things like that. I'm going to focus much more on access to information, what the security system was at LAPD for handling the information in this case, and what her role was in that, and how that relates to the leaks. I'm going to make it, I think, even more focused.
All right, well, this is a 402 hearing.
Right.
All right. And I understand we have counsel from the City Attorney's Office.
Yes, good morning, Your Honor. Arthur Walsh, Assistant City Attorney, here on behalf of Ms. Kessler.
All right, Mr. Walsh, have you had the opportunity to consult with defense counsel regarding their reasons for asking for this 402 hearing this morning?
No, Your Honor, I have not.
All right. Do you have any comment, or have you discussed this with the District Attorney's Office?
I understand, both from talking to the District Attorney and from general press reports, what the scope of this is intended to be. And I, at present, have no objection to questions directed to the witness regarding her own personal knowledge of these matters. However, should questions intrude into her knowledge of any internal affairs investigation or any matter relating to personnel records of police department employees, I will make appropriate objections at that time.
All right, then the court will note your presence for the record, and you may rise to assert any objections at a time you feel appropriate.
Thank you, Your Honor.
All right. And Ms. Kessler, what are your time constraints this morning?
I believe I can.
Okay, well, let's get started.
Your Honor, for the record, as the court knows, we did object to this procedure, given that there's no offer of proof. And in a 402 hearing, you do not necessarily have to call live witnesses, since it's merely a pretrial ruling of how the court would later rule at the trial itself.
Mm-hmm. All right, your objection's noted for the record. Thank you.
Your Honor, Ms. Kessler says she has to leave at, what time did she say I missed?
10 o'clock.
10 o'clock, thank you.
All right. Mrs. Robertson.
Michelle Kessler, Michele Kestler.
Mr. Neufeld.
Thank you. Good morning, Ms. Kessler.
Morning.
Ms. Kessler, what is your current title?
Currently, I am the Laboratory Director or Chief Forensic Chemist for the Los Angeles Police Department.
And as of June 12, 1994, what was your title?
As the Assistant Lab Director, or one of the Assistant Lab Directors for the Los Angeles Police Department Crime Laboratory.
And when did your title change?
Sometime in July, I don't recall the date.
Sometime July 1994?
That's correct.
Now, as the laboratory director, do you have, and before that as the assistant laboratory director, do you have some day-to-day management responsibilities for the various units within SID?
Yes, I do.
And during that time period frame from June of 1994 to the present, was it also your practice to on occasion take responsibility for managing some of the larger cases?
Manager, more oversee, not necessarily manage, oversee and stay involved and help cause them to proceed at a somewhat normal pace as opposed to helter-skelter.
Okay, and in this particular case, did you play a role in overseeing the processing and handling of this case?
I was attempting to assist in that process because at that time, Mr. Matheson, there was no other assistant lab director, so I played a little larger role than I normally would.
Well, for instance, you were contacted by the police as early as June 13th at your home to be informed about what was going on. Isn't that right?
Just to tell me that a large case had taken place.
And you had meetings shortly after that on June 15th with Marcia Clark and other people about the processing and handling of evidence, didn't you?
This is not relevant to the 402 issues, Your Honor.
It's not real relevant, counsel. We're talking about September issues.
Well, Ms. Kessler, this case was given a special designation of a confidential case, was it not?
Yes.
Okay. And as a confidential case, are certain different procedures set up to maintain security of the testing of evidence and for the results of the testing of evidence?
The testing of evidence, and I'm not sure I understand your question. I can answer half, and then I'm not sure that's
All right.
answering all of it. As for the testing of evidence, no, the testing is still done under the same process.
All right. What about the dissemination of test results and information? Is it shared differently in a case once it's been designated confidential?
Well, we normally, the laboratory only shares the results with the investigating officers and with the prosecutorial agency. That doesn't change either, other than the results are held in a separate secured area, usually a supervisor's office, file cabinet, someplace, until such time as it's over.
And in this case, is that the procedure that was utilized?
Yes.
Now, when you say that the test results are shared only with certain select people, in this particular case, who were those people, first of all, at SID, with whom the test results would be shared with?
All right, why don't we rephrase that question because it's vague.
Okay?
We're talking about a certain set of test results.
All right, let me back up one step. Were you also designated as the laboratory director to be the point person at SID, to be the recipient of reports governing test results in this case that were mailed to SID from outside agencies?
That is, I'm always the point person for all test results, only because they are addressed to me so that they don't go to the bomb squad or some other portion of SID who would know not what to do with them.
For instance, you had test results mailed to you
Oh, they would know
in
what
this
to
case
do.
from the Federal Bureau of Investigation, is that right?
They would manipulate the results because apparently, and we've seen a million cases, the police harass and are out to get specific individuals.
Well, it's vague as to whether she physically received
Police
these
are harassing me. I'm suing you all. I'm suing you.
Were the results that came from the FBI addressed to you, Michelle Kessler, at the SID laboratory?
It's unclear to me. I don't recall whether we actually received them directly in the laboratory or whether they went to the court at that time. I've forgotten.
Let me just see if this refreshes your recollection.
Counsel, I'm going to sustain the court's own objection. I'm not interested in this.
I think, Your Honor, it's going to become very, very relevant in about 5 minutes.
Nope. We're talking Cellmark here, and we're not talking FBI.
All right, I can even explain it in front of, there's no problem, Your Honor. The issue is that at the same time that the report was received from Cellmark, they also received a report from the FBI regarding the hair and fiber analysis.
It's irrelevant.
Which was also leaked to the press the same day.
It's irrelevant.
Okay.
The only thing I'm interested in is whether or not
Right.
the Cellmark results.
Right. All right. Have you seen a report from Cellmark Laboratory dated September 8th, 1994, that was faxed to Michelle Kessler at the SID laboratory on September 12th, 1994?
Objection vague at the time.
Oh,
I saw a report dated September 8th, a hard copy of that report, that at some time was faxed, but it was not faxed to me. It's addressed to me. I do not know what the cover fax, who the fax was sent to, or when.
you don't know to whom this was faxed?
No, it was, again, my name is on the header, but I don't know what the fax cover sheet would have said, nor did I ever see it.
Your Honor, at this time, I would like to introduce, for the record, for the Court's consideration of these issues, a 1, 2, 3, 4, 5-page report from Cellmark, which is a report dated September 8th, supplying results of DNA testing on the Bundy drops. with a fax from Cellmark of September 12, 1994.
And does this document
You better go
have
with
the
him.
imprint of
You
the
need to
number that
learn the
was
new
faxed
math.
to?
No, it has just the imprint that it was
How
really
many
faxed from,
people can do the new math
that
in
I
this
see
chat?
on this particular sheet.
I'm already going to tell you it's 0. 0.
The copy that we were provided by the prosecution in discovery says where it was faxed from on September 12th, 1994. It's addressed to Michelle Kessler at the Los Angeles Police Department. What we also have in conjunction with this, which we received in discovery, and I'd like to introduce at the same time, because it came at the same time as part of the same discovery, was a cover sheet from the Los Angeles Police Department Scientific Investigation Division of a fax from Michelle Kessler to Marcia Clark at the Los Angeles County District Attorney's Office dated September 16, 1994. In other words, we only received a
Understand.
copy
Okay.
that the District Attorney received.
Mrs. Robertson, what is the next in order for defense exhibits?
Were you on
All right,
con the whole
Cellmark
time?
report of dated September 8th, addressed to Ms. Kessler, will be 1281, and 1282 will be the fax of Ms. Kessler to Ms. Clark.
Your Honor, I wonder if I might have the opportunity to review these. I haven't seen them.
All right, Mrs. Robertson, would you have the staff make copies for everybody, please? It would speed things up in the future if you're going to use documents that we have multiple copies available.
I apologize, Your Honor.
All right.
Sanctions. No apology. Sanction.
All right,
$250.
I want to just show her a copy of that document to see if it refreshes her recollection as to a report that she did, in fact, see from Cellmark Diagnostics. But,
Well, she's testified she saw it.
okay. All right.
She's familiar with what the report is. The issue is when did she get it and when did she see it?
Michelle Kessler, you were at the office at certain points in time on September 12, 1994. Isn't that correct?
That's correct.
And you said that given the fact that this was a confidential case, only certain people at SID were given access to reports or to this report, if you will. Is that correct?
Objection. That misstates the testimony, Your Honor.
Roll. Counsel, Mr. Walsh, I'm going to allow you to make objections concerning the scope. However, the prosecution is the real party in interest, and if they choose not to make evidentiary objections, that's their choice.
Thank you, Your Honor.
Could you repeat the question?
Sure. Given the fact that this was a confidential case, who at SID did you authorize to have access to the Cellmark report dated September 8th that was faxed to your office on September the 12th?
Assumes facts not in evidence that she made such authorization.
Overruled.
I didn't know the report was coming, so I would have given no such authorization.
Well, prior to this report coming, since you said this case had already been classified as a, had already been characterized as a classified case, had a decision...
Sustain. Rephrase the question. Confidential case.
I'm sorry, what?
Confidential case.
Oh, confidential, I'm sorry, thank you. Since this case had already been characterized as a confidential case, what policy was in effect as to who at SID would have access to the reports that came from Cellmark?
Anyone that was involved with the serology aspects of the case, which at that time would have been off the top of my head, and like there could have been more because I don't remember who was doing what moment. Mr. Matheson, Mr. Yamauchi, and those are the only two that I can recall at the time,
And of course yourself.
and myself.
And it was your practice to read the reports from Cellmark at some point after they were received, isn't that correct?
Not necessarily. Sometimes Greg Matheson would just fill me in on what it was.
Ms. Kessler, do you recall having a discussion with me and Barry Scheck at the office of the city attorney on July 13th of 1995?
Yes.
And at that time, during that meeting, didn't you say that you personally read every single Cellmark and DOJ report that came to the office?
No, I didn't say that.
Okay.
I said I looked at them if we got them, but we never got any DOJ reports.
Okay. So you said, in other words, that you did look at those reports that did come to the SID laboratory. Is that
Yeah,
right?
but I didn't read every single one word for word, no.
Okay. So it would be a fair statement that you did look at this report which is dated September 8th, and that was faxed to the SID laboratory to Michelle Kessler at some point.
At some point, I saw a copy of the fax.
Okay. So you're saying that the only three people at SID who would have access to this report would be Colin Yamauchi, Gregory Matheson, and yourself. Is that right?
Misstates the testimony asked and answered.
Overruled.
Those are the only people. However, this report was faxed to someone. It was not faxed to me. I don't know who that individual is. So that individual would have to tell you who had access to that report.
Didn't you tell us on July 13th, Ms. Kessler, that the person who actually received the fax at the fax machine was Gregory Matheson?
I'm assuming that, but I don't know that personally. I don't have personal knowledge of that.
Did Gregory Matheson tell you at any time between September 12th, 1994 and today that he was the person who stood by the machine and personally received it?
Calls for hearsay.
It's a 402 hearing, Your Honor. I believe the court can consider hearsay.
Sustained. Rules of evidence still apply, counsel.
As the head of this laboratory, do you know who it was who received a fax on September 12th, 1994 at the SID laboratory?
No foundation for personal knowledge. Calls for hearsay.
Overruled.
I have no personal knowledge of who received it.
As the
All right,
head
hold
of...
on, hold on. Where's the fax machine located in the laboratory?
It's in the internal offices outside my office. It would
Right.
be like back in your chambers.
So it's part of your office complex.
That's correct.
All right. And who is the SID person whose job it is to maintain the fax machine, to keep it full of paper?
Well, at that point, we had no one because I didn't have a secretary. So it was just the people within the offices.
Proceed.
Did you at any time, as the head of the laboratory, undertake to find out through an investigation who it was who personally received the fax on September 12th, 1994 from Cellmark Diagnostics?
Not relevant and calls for hearsay.
Overruled.
I can say that I was told by someone that they received it.
And who was that person?
Calls for hearsay, Your Honor.
Overruled.
Greg Matheson.
Motion to strike.
Overruled.
Now, you said that you named the people at SID who were given access to that report. You also said a little bit earlier that people in the investigating agency were also entitled to have access to that report. Did I misunderstand you?
I didn't say they had access to the report. I said that we would have told them what was in the report if they had asked.
All right. And who were the people at the investigating agency who would be entitled to be told what the substance of the report was, had they asked?
No foundation.
The lead investigators, Tom Lang, Phil Van Adder, and I suppose if Captain Gartland had ever asked for it, he would have gotten it, for example.
Okay, enough torture for one day. She's here for a while. Oh, and then he's back. He's still back. He's still back when we scroll down a little bit through the videos. So, he's gonna be the witness that never ends. There is a witness coming up that's on the stand for quite a while. I won't say who it is because I don't know. But it's a man. And then she comes back. Yes, she does. I'm trying to see who else might come back. Oh, boy. And then there's that day. There's August 4th. No, August 28th, I mean. Wait a second. That's not right. It's not August. Yes, it is. It starts August 28th, and then it goes the whole way through. It's a couple days worth of bleeped out videos. Ah! All right. We'll see y'all tomorrow. Get your naps in now before Thanksgiving, okay? Bye, guys. Thank you so much. See ya.